Okay, so welcome everybody. I'm really glad you're all here this afternoon. Um, as you know, this is a little bit different for us, but we've kind of adapted to this whole environment over the last few months. So I'm sure everyone is familiar with it by now in some way or other. So this should be a good class. I'm going to ask you a couple things. Right now, everyone is muted, and I'd like it to stay that way throughout the presentation just because if we get background noise, you're not going to be able to hear me, and then everybody's going to miss out. And there are a lot of people in the room. Another thing, I'm going to take questions, but I want to hold the questions to the end because this presentation it follows in a pretty logical flow. For those of you who've been through my classes before, I normally take questions throughout, but I want to hold these off to the end. Again, it's pretty straightforward, and then we'll have time for questions at the end, I promise. And I'm going to ask you to submit the questions through chat. But again, wait until I ask you to, because I don't want to miss the questions. And if you're submitting them while I'm presenting, I might miss some. Okay, so with that being said, welcome. I hope everybody is safe and healthy. I hope you're all adapting to this well. For those of you who don't know me, my name is Mike Evans. I'm in our Benefits Officers Liaison and Development Group. I've been at OPM my entire career. I've been with OPM for a little over 29 years now, and I pretty much grew up in retirement. So I've done everything from hunting down lost and stolen pension checks with Department of Treasury to processing retirement claims to actually doing training for the people who actually process the claims to what we do now, which is training agency HR professionals. I also did that with the USDA grad school for a while in partnership with them. So that being said, today's class is going to be about settlement guidelines. I know a lot of HR people get questions about settlement agreements. A lot of times they're just brought to you, and I've had specific people tell me that they've been brought a settlement agreement and going, hey, is this okay for retirement? And so essentially what we're dealing with here in this class is giving you the material to know when it's okay, generally speaking. Now, all that being said, again, OPM has to agree to these settlements. So they are still going to need to be forwarded to OPM for review. But generally speaking, if they comply with the settlement guidelines, they're probably going to be okay. It's just getting them into even that form can be a challenge. I've seen plenty of settlement agreements, and I can tell you guys, I've seen things that in no way, shape, or form are legal. So we want to try and avoid that, because obviously if they conflict with law, we're not going to be able to honor those. And then you guys may end up as an agency going back into litigation with an employee. So all that being said, I'm going to share my screen now and get started with the presentation. Okay, so one of the general principles here is, sure where that is. Okay, the retirement fund is not a litigation settlement fund. Again, be very careful whenever you're entering into settlement agreements, because these settlement agreements are something that, you know, the retirement fund is not a litigation fund essentially. So we do not want to use the retirement fund for that. There is a separate fund for that, and we'll get into that in just a minute. But the retirement trust fund is essentially the fund where, you know, it funds all our retirements. It funds everything from our disability retirements to our regular voluntary retirements. And that fund is financed through our contributions and the agency contributions. So you really do not want to use the retirement fund as a litigation settlement fund. Now, in addition to that, a settlement may not provide retirement benefits beyond what a court or administrative body could order as relief in litigation. So you really are bound by what a court could order. And that's essentially it. We're going to go into more detail with all of these bullet points in a little bit. Now, a settlement, again, can't be implemented which conflicts with express provisions of SERS or FERS. So essentially what I'm saying here is that with the settlements, they cannot exceed what SERS or FERS could originally provide. You can't give somebody a higher computation than the retirement computation would allow. So if a settlement involves retirement, the retirement laws that are in effect are going to be in place, and that's what we're going to have to operate by. Okay, settlement personnel. I'm sorry, I am having just a little bit of trouble here. I'm not sure why I've got one person showing up on my screen. Give me just a second here. We're going to try this again. Okay. The settlement of personnel action should include consideration of the total cost to the government. And we're going to talk about how to compute that, actually. It's kind of an interesting process. For any of you who have ever done actuarial reductions before, the process is very similar. So that's one of the things to take into consideration. What is it going to cost the government? Is it going to be more costly to litigate a case, or is it going to be more cost efficient to actually settle it, and under what conditions are we dealing with? Now, the employing agency or the judgment fund must make all employee and employer contributions to employee benefits programs. That is really important as well, because those benefit programs, federal employees' health benefits, federal employees' group life insurance, all those things need to be funded as well. All those costs have to be paid. So it's going to be up to the agency or the judgment fund that the agency uses to settle those to make the contributions to those benefits programs. Now, there are special considerations involving reemployment or back pay of an annuitant, because as you can imagine, if somebody enters into back pay, well, you're paying them back pay because they are essentially on the agency's rolls. So by doing this, if the person is already retired, they can't be on the agency's rolls and be retired at the same time. So if you're dealing with something where you're basically canceling somebody's retirement, reinstating them to employment, and then retiring them again later on, there are going to be some special considerations and some adjustments that are going to need to be made with that. And I'm going to go into a little bit more detail in that as well, because that's one of the things that really seems to hold up these settlement agreements. And we get into the issue of, well, what do we need and how do we move the money around? So we are going to talk about that in just a little bit. Now, a fundamental principle of settlement authority is that the retirement fund, again, is not a litigation settlement fund. Use of the retirement fund is limited to payments of benefits expressly under SERS or FERS and the cost of administering those benefits. So again, the retirement fund is simply to provide a retirement benefit. It is not, in essence, a way to resolve an issue between an employee and the agency. There's a separate fund called the litigation fund that can do that. Now, before we go on, I am actually going to stop for just a second and ask you guys, can you hear me? Awesome. I'm seeing lots of yeses. So, okay, we are very good here. Okay, now, again, the retirement fund is not a litigation settlement fund. I know I've said that several times already, and you're going to hear this as a repeat throughout the whole thing. It is so funny because this is a point that we need to keep driving home, because no matter how many times I say it, inevitably we will get settlement agreements where this is something that gets incorporated. You don't use it to underwrite settlement agreements in cases specifically involving a determination of, you only use the retirement fund to create retirement for retirement purposes. It's not acceptable to create eligibility for an annuity or an enhanced annuity for purposes of a settlement, absent a specific statutory authority other than in Title V. Okay, I am sorry, I'm just, okay. The judgment fund, which is under 31 USC, is available and appropriate for making specific provisions of paying judgments and settlements and litigations involving federal employment issues. So the judgment fund is what really should be tapped into and used whenever you're dealing with something like that, in most cases with settlements. The judgment fund, not the retirement fund, is the one that's going to bear the cost for that. Because again, the retirement fund is simply there to provide retirement benefits. Settlement provisions enhancing retirement benefits should be entered into only where there's appropriate legal authority for the settlement. Like, for example, the Back Pay Act. So to give you an example of what that would look like, let's say we've got somebody who retired or they were removed and they were eligible for potentially a discontinued service retirement. Okay, so they were removed involuntarily, they applied for retirement. In the meantime, they were contesting that removal. Let's say they prevailed, or you go into a settlement agreement with the person because you suspect that that removal is going to be overturned. So you enter into a settlement agreement with them, in which case now you're bringing them back on the rolls with back pay. So now you've increased their length of service. So in that case, it would enhance the retirement benefit because now you're adding more service and potentially increasing the high 3 average salary. Another example of that would be to say, for example, say somebody retired, but they were also contesting that they didn't get a within grade increase or they didn't get a promotion and they prevail. And this is after retirement. Well, then again, you're going to owe them back pay, in which case the high 3 is going to change, which again is going to increase the annuity amount. So that's an example of the Back Pay Act affecting retirement. Title VII under the Civil Rights Act is amended. So this is, again, another instance where it might affect retirement. Now, what do we have to consider when we're entering into settlement agreements? Well, the big thing is the substantial cost to the retirement fund of providing the employee enhanced retirement benefits over time. And again, I'm going to talk about how we actually compute that in a little bit. Also, the amounts of retirement deductions and agency contributions under CSRS or FERS. So again, remember, the agency is going to have to pay all those retirement contributions as well. Both the agency and the employee share in a lot of cases, especially if you're going into back pay. So now, if you bring somebody back on the rolls, obviously, prospectively, that employee is going to pay the retirement deductions for themselves, and the agency is going to put in the agency share. But if we're dealing with something where you go back retroactively and alter something, in most cases, there are going to be additional retirement contributions owed, and the agency is really the person who's going to need to pay that. Now, examples to the total cost to the government of EEO settlements affecting retirement provisions are included in the EEOC's directive. It's MD 110 and it's Chapter 12. Now, they can't, terms of the settlement can't provide more than a court could impose. So settlement terms can't be more detrimental to the retirement fund than a court or administrative body could impose. So again, you can't have something being created here that would be more detrimental than a court could impose. And it's true for those cases alleging prohibited discrimination as well as others. It's just something, the terms of the settlement have to conform to the law, to Title V and retirement law. So I'm going to give you an example. We've got an employee whose date of birth is August 1st, 1961. They have a service computation date of 1/15/1995. Their coverage is FERS. They were removed for misconduct on August 15th of 2018. So what can we do in a situation like this? Reinstatement of the individual with back pay if it's determined that the charge was erroneous. Okay, so essentially canceling the separation, taking the person back, giving them back pay for that entire period and letting them go forward. That's one thing that could be ordered. What could not be ordered would be a 2-grade level promotion affecting 3 years prior to the removal at issue. A claimant may try and ask for that, but to create a higher annuity by making the high 3 grader. But because the court or administrative body couldn't order something like that, the settlement can't provide it either. You can't order something that wouldn't have occurred normally or the court could order. So that's really what we're getting at with that. Now, another thing we have to consider is that there's no implementation of the settlement if it conflicts with other provisions of SERS or FERS. So again, all of the settlements that are entered into that involve the retirement fund must abide by the annuity calculation formulas and the limitations on retirement eligibility that Congress has imposed. And this applies to all cases. So let's look at another example of that. And you're going to see this a lot with discontinued service retirements. Okay, discontinued service retirements or DSRs. The provisions are located in Title V, United States Code 8336D1 and 5 USC 8414B1 for SERS and FERS respectively. Okay, so anytime, for those of you who are, I doubt many of you, if you're in this class, are new to the law, but generally speaking, just to give you an idea, when you're dealing with 5 USC, generally speaking, the chapter that starts with 83 is going to be dealing with SERS, 84 is going to be dealing with FERS. That's not for everything because obviously we have reemployed annuitants and we have FERCA and other things, but generally speaking, if you're dealing with just the regular stuff, eligibility computation and whatnot, you're going to see 83 as the first 2 digits relating to SERS and 84 relating to FERS. Now, if the settlement conflicts with the provisions of SERS or FERS, an employee meeting certain age and service requirements who's involuntarily separated for reasons not involving misconduct or delinquency is entitled to an annuity. Now, we know that the requirements for a DSR are, if under both SERS and FERS, are you have to be at least age 50 with at least 20 years of service or any age with at least 25 years of service in order to qualify for an immediate annuity. Agencies may agree in a settlement agreement to change a misconduct separation into a DSR qualifying separation, but only when the agency makes a good faith assessment that the court or administrative tribunal could order such a remedy. And if the agency concludes that that could happen, that a court or administrative body like Merit Systems Protection Board would overturn the misconduct separation, it can agree to settle for the DSR qualifying result. However, you do have to do the analysis. Without an analysis like that, an employee in an agency can't agree to the DSR related relief. So you're going to need to have some kind of analysis to prove this as well, to show that you actually did the analysis, that yes, it looks like it's likely that a court would overturn this misconduct separation. Now, immediate retirement provisions are, again, covered under 5 USC 8336 or 5 USC 8412 for SERS and FERS, respectively. Now, for immediate retirements for age and service under SERS and FERS, for CSRS people, it's age 55 with 30 years of service, 60 years of age with at least 20 years of service, or a person who's age 62 with at least 5 years of service. For FERS, you have to be at your minimum retirement age with at least 30 years of service, age 60 with 20, 62 and 5, or under FERS, we have that special provision, the MRA plus 10. So somebody who is at their minimum retirement age and has at least 10 years of service would be eligible for an immediate retirement. However, of course, as we know, minimum retirement age in 10 years has a substantial age reduction. Now, the minimum retirement age, again, just as a review here, is the earliest age at which an employee can retire with an immediate unreduced annuity if they have between 10 and 29 years of an immediate reduced annuity if they have at least 10 to 29 years of service, or with an unreduced annuity after 30 years of service. The MRA really increases over time. Right now, if you're born 1970 or later, your minimum retirement age is 57 years old. If you were born earlier than that, it ranges anywhere between 55 and 57 years old. And it goes up every 2 months, and that levels off at age 56 for a while, and then it starts going back up again. If you need the reference for that, that is actually, there's a table in chapter 42 of the SERS and FERS handbook. The specific reference is 42A 1.1-2. Now, again, settlements must be consistent with these specific statutory requirements. So let's look at an example here. You've got somebody whose date of birth is August 1st, 1965. They're age 53 years old. Creditable service is 30 years. The separation is voluntary. The settlement provides that a former employee will receive an immediate annuity commencing on October 1st, 2021. You can't do that, okay? Because the person is not at their minimum retirement age and they have 30 years of service, but they aren't at their minimum retirement age. So that's not in line with the law. That's nothing that could be awarded in a settlement agreement. So again, not possible here. Now, what could be ordered in a case like this would be giving a person back pay and keeping them on the rolls, or something else, but you couldn't do this because it's directly in conflict with the eligibility requirements which are laid out in law. Now, that's the immediate and DSR part of this. Let's look at the disability retirement provisions for a second. CSRS and FERS provide for disabilities, as you all know. I'm sure you've seen plenty of them. Those are laid out in 5 U.S.C. 8337 and 8451 respectively. Both statutes require OPM to determine that the individual is unable to perform the duties of their position because of disease or injury. Now, no settlement can guarantee disability retirement under either CSRS or FERS without independent OPM approval, because OPM is the agency who makes the final determination as to whether the person is disabled from that position or not. So you can't guarantee it as an agency because, well, of course, you're not the one who's going to be the final arbiter as to whether or not that person is disabled. Now, again, under both CSRS and FERS, an application for disability retirement has to be filed with OPM within 1 year of separation. This is a big one. For disability retirement provisions, once a person is separated, they have 1 year to apply for that disability retirement from OPM, 1 year from the date of separation. The law allows a tolling of this time period, but only on the grounds of mental incompetence. And even then, the law is a little, it's not just, okay, I'm mentally incompetent, so I didn't apply. That clock for the 1 year starts once the person is assigned a guardian. Okay, so when that person has somebody to manage their affairs, if they are mentally incompetent, the clock starts because now it passes to that person who the guardian has the responsibility now to apply for the benefit. So, but if the person is mentally incompetent for a period of time, let's say 2 years, and then something happened and they became competent again, at that point they may apply for a disability. And of course we would need proof of that. Say they were institutionalized. Say that because of the disability they were removed from their position, they had no family members, they were institutionalized, there was nobody to assist them, and they recovered within 2 years, or if not recovered, at least got to the point where they were competent enough to file for a disability. And then they did that. In a case like that, we would look at all the medical documentation and determine that, okay, it was due to mental incompetence that they could not apply. But other than that, there really is no exception to that 1 year time frame. Now, if a settlement agreement is to permit an individual to apply to OPM for disability retirement, the application must be within this 1 year statutory period. So again, entering into a settlement agreement with somebody after they've separated and it includes a disability retirement, if you're dealing with somebody and this has gone on for more than a year, you can't just say, okay, they can apply to OPM. I mean, technically they could apply to OPM, but it's going to be denied if the time frame that has passed is more than 1 year. And at that point, then I think the settlement would be rejected. Let's look at an example here. We've got somebody who's age 45. They've got 9 years and 6 months of creditable service. Their separation date was on 7/15/2015. They applied for disability retirement on 9/1/2016. this time period exceeded the 1-year statutory time limit for filing. So, and the former employee is not and was not incompetent. In a case like this, disability is not acceptable. The agency agrees to place the individual, and what also is not acceptable is if the agency agrees to place the individual in a non-pay status solely for a period designated to meet the statutory 1-year requirement. That we have seen attempted quite a few times. This slide I want everyone to focus on, okay? This example here, the disability example, we've got somebody who has been separated for more than a year. The agency enters into a settlement agreement. You cannot agree to place an individual in a non-pay status solely for the reason to meet the 1-year time frame to apply for the disability. That cannot happen. You cannot put the person in leave, cancel the separation and put the person in leave without pay just to meet the 1-year time frame so they can apply. That is not acceptable in any case. What is acceptable would be if the agency agrees to retroactively reinstate the former employee to the employment roles with full back pay and benefits for the period necessary to bring the individual to the date that they could apply within the 1-year time frame. So if you see the difference here is putting a person in a non-pay status versus reinstating them with back pay. Again, that person would have to be paid. The retirement fund would have to get the contributions and the agency share. All the other benefit programs, FEHB, FEGLI, would have to get their portions as well. And you could bring the person back, reinstate them onto the rolls with full pay and benefits for the period necessary to meet the 1-year rule. But just putting them in leave without pay is not acceptable. And I've seen the leave without pay thing attempted many times, and that's usually the first thing that we see that we can reject a settlement agreement. So please be aware of that. Please make a note of this. This is an important point. Now, I want to talk about something else that involves disability. This is the Brunner presumption. It was Brunner v. OPM, and it was a Federal Circuit decision back in 1993. The employee is discharged on grounds of inability to perform the job. When the employee later applies to OPM for disability retirement, the individual is presumed disabled for purposes of entitlement to a disability retirement, okay, because they were removed on grounds for inability to perform the job. So we are going to presume that they were disabled for purposes if they apply for a disability. Now, of course, we're going to look at the medical documentation and stuff. So OPM is not going to unconditionally apply this presumption. An employee is separated for misconduct or other non-medical related performance grounds, then that presumption is not going to apply. By agreement, documentation is changed to base the separation on the medical inability to perform the job. That is not acceptable, okay? Where it's done to merely enhance the individual's application for a disability annuity, OPM will not apply the Brunner presumption. Okay, so you see a very different thing here. When the employee is discharged on inability to perform the job and then they apply for disability, OPM is going to presume that they're disabled or look at the medical documentation as well, but our initial presumption is going to be that the person is disabled. When we see that an employee is separated for misconduct or other non-medical reasons, and there's a settlement agreement and the documentation is changed to make it a medical inability to perform that job, then we're not going to apply the Brunner presumption. Now, if the medical evidence demonstrates that the original personnel action was erroneous because the individual was unable to perform the job, and the fact that the agency was unaware of the medical condition at the time of the separation, OPM then is going to apply the presumption. So see, there's an even subtler layer here. In example 3, this was done, or in slide 3, where it's done merely to enhance the individual's application for a disability application. That's when we're not going to apply it because the person was separated for misconduct. It really wasn't medical, but the agency entered into an agreement to change it on medical inability just to enhance the benefit. That's not acceptable. However, if a person is separated due to misconduct, for example, and the agency was unaware that there was a medical condition going on at the time, and the agency then later discovers that, oh, the person has a medical condition, and one of the side effects of this medical condition is outburst, some kind of misconduct. Then OPM will apply the Brunner presumption because the agency can then correct that information. Now, settlement of personnel actions should include consideration of both the total cost to the government, and both CSRS and FERS expressly provide that entitlement to an annuity requires completion of specific periods of federal service. And we looked at that, right? 55 and 30 for CSRS, MRA and 30 for FERS. So there are specific age and service requirements. Now, there are a few cases that represent unusually high litigation risk, or it could set a precedent resulting in substantial future costs to the government. If you're going to enter into one of these settlement agreements, it should not be taken lightly. I mean, there are things to consider here. Both retirement systems also expressly provide that annuities are to be calculated upon the basis of federal service performed and pay levels attained. So again, you have to perform the service, you have to attain certain pay levels. You can't just jump ahead and give somebody a promotion, things like that. Entitlement to annuity benefits and the amount of the annuity is based on specific pay levels and periods of service. Again, remember, our high 3 average salary and the length of service is what determines what we get as an annuity. Now, again, it's not consistent with congressional intent to regard periods of service to have been served or pay to have been received to gain title to a retirement annuity. What I mean by that is going back to our disability case. If we've got somebody who is, again, put in a leave without pay status simply to meet an eligibility requirement, that's not consistent with congressional intent, or to deem somebody to have performed service when they didn't perform it, or to gain title to a retirement benefit. Now, if an agency is considering such a settlement, it must determine the total cost to government of the settlement. The full projected value of a lifetime annuity must be considered, and the sum of the agency and employee contributions. Now, the whole total of this is going to reflect whether the settlement is in the best interest of the government. Now, that sounds like a lot, right? I mean, you're looking at the total cost. You're looking at the value of the annuity over somebody's life, as well as the cost to the agency for the employee contributions and agency contributions, the contributions to FEHB and FEGLI, and all that other stuff. Think about it in the way, probably the best reference for you if you've never done one of these projections is to think about FERCA for a second, and think about what happens in a case like that where you're comparing two retirement systems, right? And you're looking at somebody who was covered under one, and this is what they would have gotten, and then if they're covered under this, this is what they would have gotten, and so you're looking at the cost of that. Okay. Now, even in those unusual situations that we talked about, the settlements can't exceed the relief that would be awarded upon a finding of a wrongful or erroneous personnel action. Those settlement terms may include only enhancement of retirement benefits that could have been awarded as part of an adverse action. So again, you can't give somebody who's 53 eligibility to an immediate retirement, an immediate voluntary retirement, if they have 30 years of service because they haven't met the eligibility requirements for an immediate voluntary retirement yet. You can only give them what would be awarded as an adverse decision. So again, that could include bringing them back on the rolls with back pay. It could mean that somebody is claiming discrimination, that they didn't get a promotion, so you award them that promotion retroactively. And of course, then everything prospective, including the within grades, all that other stuff comes into play as well. Keep in mind too, you're also going to be dealing as that salary goes up, particularly if that person is FERS, which in most cases now they are. You're not only dealing with the salaries, if that person is contributing a certain percentage of income to TSP, you're looking at that and the 1%, automatic contribution, all that stuff is coming into play here as well. So again, probably the best reference point for you would be looking at the costs associated with the FERCA case in some ways. That's probably the best similar example that I can give you. Now, in all the circumstances, a settlement must provide that applicable retirement deductions and agency contributions be paid into the retirement fund. I know we've said that multiple times. The retirement fund needs to get the money, essentially. We need to do that. The retirement fund needs the money. Anytime you're entering into a settlement agreement, because the retirement fund is not a settlement fund, the retirement fund needs to be completely made whole. Because again, you know, this is where everybody who retires on disability, this is how they're paid. This is where everything comes out, right? This is where our retirements, even if they're voluntary retirements, come from, and stuff like that. So just be aware of that. Now, if a settlement provides that an individual is to receive an enhanced retirement benefit because of a deemed increase in pay levels or an additional period of service, the deductions and contributions have to be paid to the retirement fund in full. And that's pretty basic, right? If you're going to award somebody back pay or you're going to increase their pay levels, this is going to affect everything. It's also because, of course, the retirement deductions are based on the percentage of the salary. So, of course, the retirement contributions are going to increase for both the agency and the employee. Now, application of that principle places the financial burden on the agency that took the action and to the judgment fund. Now, here's the fun part. We're going to look at quickly at how we compute this cost to the government. Before we do that, I did notice that we had a couple questions, and I am going to go to the chat really quick. I know I said we were going to hold off to the end, but I really want to see what we're looking at here. So let's see something. I am only showing. Okay, here we go. Okay, so in example 3, let me go to that. In example 3, could they request a within grade increase insist on automatic action? In example 3, let me go back to example 3 real quick here. Okay, sorry about that. Yeah, I mean, if the within grade increase complied with law, then that's correct. I mean, if you're reinstating somebody retroactively, obviously you have to conform to all the pay and leave rules. So again, if the within grade increase, or if the person was denied a within grade increase, if that was withheld for some reason, you could order it. But you can't give somebody a within grade increase that wouldn't normally have occurred, because that would be in violation of the pay rules. So hopefully that answers the question. A retirement settlement is essentially, I am seeing a question here, what is the definition of a retirement settlement? A retirement settlement is essentially, you're involving retirement in the settlement. It's not a retirement settlement completely. The agency has an issue with the employee has an issue with the agency, with something that happened at the agency, and it somehow involves the retirement fund. Either the person was denied a promotion, they were fired or removed, and somehow the retirement fund is involved. Either they applied after they were removed and contested the removal, things like that, or they were denied a promotion, and in that case, it affected their high 3 average salary, so they're arguing that. I've got another question here. For a law enforcement officer who was removed for conduct meets the requirements for immediate retirement under LEO prior to termination, can the agency settle to change the action to resignation in lieu of to be eligible for an immediate retirement? Is there another option? Now, I know we're getting into some individual cases here. So again, with each one of these, it's going to be on a case-by-case basis. So I hate to give you specific answers for each one. if it's likely that the conduct is going to be overturned by an administrative body, an agency may enter into that. I mean, again, I would have to know the specifics of the situation. We'd have to look at that, so I can't give you a real specific answer. Example 1, 3 of 3. Okay, let's look at that real quick here. Sorry with these slides, I know. Example 1, 3 of 3. Oh, here we go. A true grade level. Okay, so we're looking at somebody who was removed for misconduct, reinstatement of the individual with back pay if it's determined this charge was erroneous. Okay. Yeah, in a case like that, and again, we go to 3 of 3, a 2-grade level promotion effective 3 years prior to the removal would not be acceptable. What would happen is when you reinstate the individual with back pay, you can do that. What you can't do is give them a within grade increase that they wouldn't have been on schedule to receive. Okay, you can't just randomly throw somebody a within grade increase. They would have to be on schedule to receive that. So again, you have to comply with pay and leave as well. Now, if that retroactive restoring them with back pay resulted in now they were on this schedule and they were eligible for a within grade increase, they would receive that potentially. If a within grade increase also was withheld, it could be potentially changed and awarded if they're contesting that. So I think that helps clarify that one. Okay. And I think we are going to move on now. So I'm going to ask you to hold your questions again because I really want to get into this part of the session, which deals with computing the total cost to the government, because this is something that needs to be done, and it's something that I think you're going to appreciate seeing this. So let's see. Give me just a second here. Let's share. Okay, so what we're going to be talking about, and the main thing we use, are the present value factors. Now, I know most of you have used these before. They're published every year in the annual changes BAL, at least the links to the current present value factors are, because the present value factors change from year to year. Not every year, but they do change occasionally. And when they do change, it's really important to know which present value factor you were using whenever that time was in effect. Now, most of you have probably seen these present value factors used whenever you're doing a retirement estimate and you're computing an actuarial reduction for a CSRS refund or something like that. So uses of the present value factor include calculating the reduction to a CSRS and FERS retiree's benefit when the retiree elects the alternative form of annuity. Quickly, the alternative form of the annuity is a different type of annuity where a person gets all their retirement contributions back and the annuity is actuarially reduced using the present value factors. That's only done if a person is terminal, and so that we see it used very rarely anymore. CSRS and FERS benefits with a CSRS component when the retiree elects to credit refunded service that ended before March 1st, 1991 without paying the deposit owed for the service. That's probably the most common time you see present value factors being used. Excuse me. CSRS and FERS benefits when the retirees marry after retirement and elect to provide a survivor annuity benefit. You guys don't see that, but at OPM we see that quite a bit. Retirees benefits when the retiree elects to credit non-appropriated fund or NAF service for retirement purposes under Public Law 104, 106 or Public Law 107, 107. Now, those, some of you, if you've ever worked with a NAF employee before, you may have seen this, okay? So generally when you're crediting non-appropriated funds service into an annuity under either Public Law 104, 106, or Public Law 107, 107, both those provisions of law require that crediting that NAS service make it cost neutral to the government. So you have to actuarially reduce the annuity to negate the increase in the annuity that that additional service would provide. So again, you're kind of using the present value factors to do that. Now, we also use them for retirement benefits for individuals with certain types of retirement coverage errors who can receive credit for service that they didn't pay for that actually increased. So you've seen this under FERCA. So if, to give you the specifics of it, say somebody was erroneously under FERS and they should have been under either SERS or SERS offset, and they had an election and they elected SERS or SERS offset, and there were deposits that they owed. Now, originally they thought those deposits were a smaller amount, right? For example, a military deposit under FERS is 3% versus a military deposit under SERS, which is 7%, or deposits for non-deduction time, which under FERS are 1.3% and under SERS are 7%. In those situations, we actually give the person who is found to have a FERC error and elects the retirement system where the deposit is going to be greater. They have a choice between making a lump sum payment or having those payments paid through an actuarial reduction. In order to do that, we use the present value factor to determine how much we reduce the monthly annuity. That's one that you may see and be familiar with using the present value factors for. Now, what is this present value factor? It approximates the number of months on average that an employee is expected to live. It can be used for financial planning as well as computing the total cost to the government. So those present value factors, they're based on the age of the employee, okay? And so whatever age you are, if you look at that present value factor chart and find your age, that's going to tell you the number of months on average that our actuaries have projected that you're going to live. And so what we do is we take whatever dollar amount it is and divide it by the number of months you're projected to live, and that's how much a monthly reduction is to your annuity. So essentially that's it. So you can use those to reduce, you can use them for financial planning as well. We're going to look at a way that we use them. You compute the monthly annuity the employee or former employee is eligible for if it's applicable. You compute the monthly annuity based on the purposes of the proposed terms of the settlement. Now you multiply the monthly annuity amounts by the present value factor. That's going to tell you how the present value factor based on their age right now is telling you how long that person is going to live. So we know how many more months we're going to have to pay this person. So if you multiply the monthly annuity by the number of months the person is projected to live, that gives you a total cost for that benefit. So if you do both of them, the monthly annuity that the employee is eligible for right now, plus the monthly, and then do a separate one incorporating the terms of the settlement, and then you subtract the two, the difference is the total cost to the government. This is how much the person was entitled to. If you enter into a settlement, this is the increased cost to the government, and when you subtract them, that's what gives you the additional cost. Now, hopefully that makes sense to everyone. A settlement affecting employees' benefits has to provide for full payment directly to OPM for the amounts of the applicable employee deductions and agency contributions for all OPM administered programs. I know I've mentioned this before, and a lot of times we've been talking for the most part about retirement contributions. But remember, there are other programs as well. There's FEHB and FEGLI, long-term care, TSP, there are things like that. So these include retirement deductions, applicable payments to federal employees group life insurance, appropriate payments to federal employees health benefits insurance. Settlement should provide for payment of deductions to OPM from the agency, even where a cash lump sum payment is involved, if that lump sum represents a portion of back pay that the individual might receive if they prevailed in the matter concerned. Now, If deductions are not otherwise paid, OPM will look directly to the agency involved for payments involving OPM administered programs. A litigant can't receive both back pay and an annuity for the same time period. So again, this is one of those considerations that you need to look at when that's going to involve the retirement fund. So say, for example, somebody retires on June 1st of 2020. They are disputing that removal. They were removed, they were eligible for a voluntary retirement, they were removed, they applied for voluntary retirement, but they really didn't want to retire. They're contesting that removal. So, or they would have applied for a discontinued service retirement at that point. I'm sorry, I misspoke. So at that point, they apply for that, they're awarded a retirement. In the process of fighting the removal action, they prevail or the agency enters into a settlement agreement with them. The agency then can award back pay from the time the person was separated to the present day. However, that person's been paid annuity from June 1st to now. So what's going to happen essentially is the amount of annuity that we paid is going to have to be subtracted from the back pay that was awarded for that time period. So let's look at an example. We've got somebody age 56, they've got 30 years, 4 months of service. They retired voluntarily on August 31st, 2016. There was a discrimination case involving a failure to promote and is ongoing as of the date of retirement. A settlement is reached in which the person is retroactively promoted with full back pay through 12/31/2016. The settlement has to provide that the amount of the annuity paid for that period must be repaid to the retirement fund. The total amount of any payments made to the person while in an annuitant status should be withheld from the gross back pay award in order that it is redeposited as a reimbursement to the retirement fund. Now, here's what I want to get to as far as a processing consideration. We do get this question a lot after a settlement agreement has gone into effect. Or what's going to have to happen in a case like this? In order for us to give you the gross amount of retirement that was paid, a lot of time an agency will come to us whenever a settlement agreement is being honored and it's all been approved and everything, and they're looking for the amount of the annuity that the person has been paid. Well, until the person is actually back on the rolls and we get the cancellation of the retirement, that the agency needs to cancel the retirement. So essentially the agency is going to have to cancel that retirement, and then if they're going to award them or allow the person to retire at a later date, that needs to happen too, so we know the entire period that is going to be affected. A lot of times agencies will come to us without having canceled the retirement, and we're still paying the person. So again, this is a moving target. We can't give you a total amount of annuity that we've paid if we're continuing to pay the annuity. You have to notify us we need to terminate the annuity, and we need to know if the person is going to be re-retired, the effective date of that re-retirement, so that we can isolate the period of time and how much money is paid to that person for that specific period of time. Okay, so just to clarify that, in order to get that dollar amount from OPM as to how much annuity we paid, the retirement action would have to be canceled, and if the retirement is simply being moved forward to a later date, we need to know that date as well. Okay, and again, as far as the whole back pay award goes, the specific regulatory citation for that is 5 CFR 550.805E. So let's look at an example here of another one that affects, and we can look at the total cost to the government. Say somebody had a high 3 before their retroactive promotion of $119,794. Their high 3 after their retroactive promotion was $122,208. Their health benefit premiums were $217.06 per month. The original annuity was based on 30 years, 4 months of service, and $119,794 is the high 3. That gave the person $36,337.47 annually, or $3,028 per month. The annuity amount to be withheld from back pay would be 12,120. That's 3,028 times 4 minus the cost of the health benefits premium. So it would be $11,243.76. The new annuity based on 30 years, 8 months of service, because we're giving them an additional 4 months of service and a new high 3 of $122,208 would give them $37,477.16 annually, or $3,123 monthly. In those situations where there's no lump sum award of back pay, the terms of the settlement must include agency reimbursement to the retirement fund for the amount of the previously paid annuity. So again, you have to reimburse the person if the retirement, if there's no back pay, and you're taking the person back on, we still need that annuity because they're essentially back on the rolls. They weren't entitled to that annuity. They're an employee. If not, OPM is going to be required to take steps to recover those amounts directly from the litigant, which of course, if the agency doesn't give us the money from that the person was paid an annuity, we're going to go directly to the former retiree and get that money, which could result in the employee renegotiating with their attorney and nullifying the settlement and reopening litigation, which is of course what you tried to avoid by entering into the settlement in the first place. So probably not the best way to do that. So again, we need to recover the amounts of annuity that were paid whenever they shouldn't have been paid. Now, under provisions of both SERS and FERS, annuity rates are computed using the average pay computations and formulas. So those computations require knowledge of grade and pay levels for specific periods of service, right? So we need to know that. Settlement providing merely for reinstatement of an individual and payment of a lump sum amount representing back pay can't support the computation of intended higher annuity rates. So that was a decision, Reed v. OPM, it was a Federal Circuit decision as well. So again, you can't just reinstate and you can't pay a lump sum amount to person representing back pay. That can't support higher annuity rates. If you're going to reinstate somebody, you need to reinstate them retroactive with back pay and all the within grades and everything else. Now, to implement any retirement benefit, the agreement must provide for personnel actions that include all necessary documentation, such as the dates of promotion or within grade increase. So again, lump sums are fine, but for that purpose, like, a settlement awards that, but they're not going to get credit for that time, as far as supporting a computation of a higher annuity rate. In order for somebody to get an increased retirement benefit, you have to reinstate them retroactively with pay, with benefits, with everything necessary, such as promotions, within grade increases, all that stuff. If a settlement provides for retroactive reinstatement of an employee with entitlement to additional service credit, SERS or FERS retirement deductions, again, have to be paid into the retirement fund to cover those periods of time. So again, the retirement fund gets their money. I mean, I've essentially been saying this through most of the presentation, but you kind of get the point, is that anything that happens that affects retirement, that service has to be fully funded. You have to have agency and employee retirement deductions have to go in. The amounts due as employee deductions and employing agency contributions are vary, and of course are dependent on whether the employee is subject to SERS, FERS, which of course includes FERS RE and FERS FRE, or SERS offset. Now, obviously FERS RE and FERS FRE have higher contribution and agency contribution rates, so just be aware of that. Again, it's one of those things that whatever the contribution rate, and of course contribution rates have changed historically over time as well. So you're going to have to look at the time period of what rates were in effect during that time. If you're retroactively reinstating anybody and the rates changed in that time period that overlap, if the retroactive reinstatement overlapped a period in time in which those rates changed. Now, as far as Social Security deductions go, employees subject to SERS or FERS offset FERS or SERS offset are subject to FICA deductions, of course. So SERS employees don't have Social Security coming out. SERS offset people do, FERS people do, which includes FERS Ray and FERS Fray. But SERS employees, you don't have to worry about Social Security. In any case, when you're dealing with FERS, FERS Ray, FERS Fray, SERS offset, FICA deductions, which are offset against the total employee retirement deduction, have to be withheld as well. The FEGLI Act, which is 5 U.S.C. 8701, and the FEHB Act, which is 5 U.S.C. 8901, create two programs which most employees are eligible. Unlike SERS and FERS retirement programs, participation is optional in FEGLI and FEHB, and of course you guys already know that. But as far as the deductions go, if an employer or former employee has, or they have had FEGLI or FEHB coverage, payments to those accounts should be considered in a settlement because in some cases those payments can be substantial. A case involving the involuntary separation or a suspension without pay of an employee enrolled under FEHB. If that case is settled by reinstating the employee retroactively, again, taking them back on the rolls retroactively or deeming the employee to have been in a pay status retroactively, and the employee intends to file claims for benefits during that period of time that you're retroactively reinstating them, then both the employee deductions and the agency contributions for the FEHB coverage have to be deposited into the FEHB fund. So again, if you're settling and you're bringing somebody back on retroactively, if they're intending to file claims during that period that you're retroactively reinstating them, FEHB contributions, both the agency and employee share, have to be deposited into the FEHB fund. If the employee doesn't intend to file claims for benefits under FEHB for that period of separation or suspension, then you don't have to worry about it. No employee deductions or agency contributions needed to be deposited into the fund. Now, as far as FEGLI goes, if it's not involving an involuntary separation or suspension without pay, such as a retroactive promotion settled with a retroactive adjustment in pay, both employee deductions and agency contributions for applicable FEGLI coverage have to be deposited in the Federal Employees Life Insurance Fund. Now, a settlement that involves an involuntary separation or a suspension without pay where the employee is deemed to have performed service or been in a pay status for a period covered by the settlement, in those cases, employee deductions and agency contributions for FEGLI coverage have to be deposited in the retirement in the Federal Employees Life Insurance Fund, only if the employee died in the intervening period or suffered dismemberment entitling benefits under FEGLI. So if FEGLI could have paid out during that period of time when you're retroactively reinstating them or giving them credit for service, in a case like that, where FEGLI would have paid out, then you're going to have to put that money in the fund. If it wasn't, then you don't. Thrift savings plan for both SERS and FERS employees, they're entitled to participate in TSP. However, there are some different rules because remember, FERS people get matching contributions, SERS people don't. Thrift Board, not OPM, administers this program. If an employee that's participating in TSP at the time of the personnel action, it would be necessary to include appropriate deposits to the thrift savings fund in any back pay awards. So again, if you're bringing somebody back with back pay, as part of that whole computation of what back pay is, you've got your gross rate, but then you also have all the deductions coming out. If the person was participating in TSP, you would have to withhold the TSP amounts as well. You would also have to include the agency contributions and any matching contributions, so just be aware of that as well. Now, with that being said, I am going to open it up to questions, and give me just a second here. Okay, so do we have any questions? Feel free to throw them into chat and I will do my best to answer them for you. Okay, or appropriate legal authority in the scenario of back pay enhancing the employee's leave or service is a high 3. Is my understanding that both funds may be used, the legal fund and the FERS fund. Both funds may be used. Well, if you're bringing somebody back with back pay, then essentially what's going to happen is the retirement contributions are going to come out of the back pay. So in that sense, you're not really using the fund, you're actually depositing money in that fund. Now the legal fund can be used in some cases if there are additional contributions or stuff, but then that would move into the retirement fund. I think I'm understanding the question. I'm not sure. For FEHB, if an employee is reinstated retroactively, wouldn't we have to pay the FEHB premiums for the entire period, regardless of whether an employee files a claim? Well, not if they didn't file the claim. That's the thing. If they didn't file claims during that period, I mean, that's one of the things that you get. And if we go back to slide 2 of 3 here, if the case is settled by reinstating the employee retroactively or deeming the employee to have been in a pay status retroactively and the employee tends to file claims for the period, then all the benefits need to be reinstated. But if they're not going to file claims for that period, then you don't need to put those funds back in. Now, let's say, for example, you've got somebody who had those funds coming out of retirement. Well, now we're talking about moving the money between the retirement fund, and all that's going to come out when we look at how much we paid them in annuity and everything. So there's a difference there. So let's see, is there a statutory limit on back pay settlements? I do not know if there's a statutory limit on back pay settlements. That would be a question for our pay and leave policy. And it's probably detailed in the regulations. But again, remember, back pay is, again, back pay. It's something that the employee would have been entitled to. So a statutory limit, I guess, would be you couldn't give somebody more than what they would normally be entitled to. So for example, the question that came up earlier, could we give somebody a within grade? Well, if they weren't on the schedule for a within grade, you know, if you're just randomly throwing a within grade at them, you can't do that. So that would be against the law and you couldn't do that. I guess there are limits in that sense. If I'm not understanding the question correctly, that's because now we're getting into pay and leave, and I would suggest reaching out to our pay and leave policy area for that. Let's see, can an agency agree to pay FEGLI? Well, in a case where where you're bringing somebody back retroactively, in most cases you wouldn't owe that. As far as affecting FEHB coverage for continuation into retirement, no, because the person has never not been enrolled. You're just not paying any premiums for that period of time. And there is a settlement agreement in there. So that shouldn't affect FEHB eligibility. I mean, a person who is enrolled in the FEHB program, if they didn't have claims during that period, then no premiums are necessary, but they're still enrolled for that period. So I don't think that's an issue. Does OPM calculate back pay to determine what's to be paid into a retirement fund, or do they accept whatever the agency's calculates and determines? Well, the agency is calculating the back pay. So unless there's a question, because again, now we're dealing with an issue between the employee and the agency. So again, if the employee disputes the agency's computation, it's going to go before MSPB, and of course you've got the regulations and our pay and leave policy, which could weigh in if it got to that. But I don't believe that OPM is going through and double checking everyone's back pay. I've not seen that. So I don't believe that we do that. Normally, at least from the retirement aspect of it, and we usually see back pay, again, in my area and dealing with, this is how it affects retirement. Somebody is already retired. Usually what back pay ends up impacting is going to be the high 3 and the annuity, because it's going to give them extra months and years of service. It's also going to give them, in a lot of cases, a higher high 3. It also is going to affect leave. So again, it's going to affect sick leave and stuff as well. So just be aware of that. But I don't believe that we recalculate unless there's a question about it. I don't know that we would have that. I mean, we get the payroll cards at the end of the day, and so this is done with payroll and the agency and the employee. So I hope that helps. Okay, do we have any more questions? Oh, wow, okay. Let's see. Contributions to employee benefits. Do those OPM administered programs include FedVIP, long-term care? I believe they do. I mean, now again, if they're coming out of the pay, I mean, clearly an employee, even after they're separated, can pay those, and they may continue paying those. So you're going to have to work with the employee at that point and determine if those payments have already been made, particularly with long-term care and FedVIP. If they've been coming out of the annuity, we're going to work with you on that as well, just like we would with the FEHB and FEGLI. Let's see, does OPM review draft settlements for appropriateness before agreement is made effective? Yes. In fact, all those settlement agreements, before you enter into them, need to be sent to settlement guidelines at opm.gov. That is really important to send those to us, because OPM does not have to honor a settlement agreement that we have not reviewed and have been a party to. So we have seen cases where an agency's entered into a settlement agreement and it has not been valid and it's never been run through us, and of course we can't honor it. So that employee will then go back and litigate it with the agency. So essentially it's going to be sent to settlement guidelines at opm.gov. Somebody in our general counsel's office is going to review that and confirm with you that it meets, that it is acceptable. Once you get that, you can go ahead and proceed. Okay, and I answered that question as well. They can be sent via email, yes. Do we send the cancellation 50 directly to OPM retirement or settlement guidelines? Well, what's going to happen when you do the cancellation 50 on the HR side of the house, that's going to generate an action on the payroll. Payroll is going to then generate, if it's a SIRS case, a 2806-1, if it is a FERS case, a 3100-1. So it's going to send a payroll card, a correction to the payroll card. In that case, what we're going to do, that's going to get fed through the same process, the 2812 system. We're going to get that, and then it'll go directly to our record center in Boyers, where all the other payroll cards go. So then we'll know that. You might want to include the cancellation 50 with the settlement agreement as well, because when it does come to retirement, if we have that, we know the date that it was canceled. Ideally, we should have the corrected IRR as well, but seeing that 50 showing that that action was initiated is going to help expedite the process. So sending us the 50 along with the settlement agreement is not going to hurt anything. That's going to actually help us. So I would suggest doing that as well. But by generating the 50, you're also going to generate an action at payroll, which is, again, going to affect the IRR, and that's going to give us the information we need as well. Absolutely. Can you type that email address into the chat? Yes, it's settlement guidelines at opm.gov. Hello. Oh, I have to select who it's going to. Everyone. I'm glad I did that because there was a typo in there, and boy, you guys wouldn't have. Yeah, that is correct. Okay, I'm going to give you one more shot at questions here, and let me know if you have anything. And so I hope you guys have found that. Oh, there's an extremely petty question. Okay, we recently had a settlement where a general counsel indicated that a disability application is routed directly to OPM. However, that is not necessarily the case. We route through NFC. To appease the employees, there a service agreement or something I can share with our general counsel that states disabilities must be routed through the payroll office for active employees. There's really your process internally where where the flow of the package. I mean, and in the Citizen First Handbook, in several of the chapters, but I believe it's in the disability chapter as well, in chapter 60 of the Citizen First Handbook. It's probably also in the planning and applying for retirement chapter, that in all cases it says that if an employee, if it's within 30 days of separation, the application is submitted through the agency, which then of course goes through payroll, because then payroll has to do their piece. Or if the person has been separated for 30 days or more, then the employee files directly through OPM. That is where you would find that information. If you need something additional, I would suggest reaching out to your liaison in my office and benefits officers development and outreach, and we can get you, we can send you an email response directly. But again, I would like to have that worked through the liaison if you need something specifically in writing. Otherwise, the Citizen First Handbook, again, chapter 60, and probably applying for retirement as well. But if I remember correctly, it's in both. I know it is in the disability chapter. So does OPM need any other documentation besides the draft settlement agreement? It depends, which I know is everyone's favorite answer. There are generally two answers that I say we always give in retirement. One of them is it depends, and the other one is it's the law, because that's usually the response that we get when somebody asks us something specific or why. Okay, so as far as the settlement, again, it depends on the situation. If we're looking at something where it's a disability, and somebody's contesting a removal, or in the case of, for example, that Brunner presumption, if an agency, for example, separated somebody on misconduct or or something like that, and it wasn't clear that it was a disability, that it was due to a medical condition, the agency didn't know. They separated them on charges of misconduct. And then later on, the agency finds out, oh, it's specifically because of a medical condition. In that case, I think we would want to see something proving that, or something relating to the fact that it was a medical condition, because then it'll help us clarify things. Again, it's a case-by-case basis. So by submitting the settlement agreement itself, if we need any additional information, we can reach back to you and say, hey, we don't have enough information here, which is why you're sending it through the settlement guidelines in the first place, so that we can actually look at it, make sure everything is there, so that we can give you a good answer. Okay. Last chance for questions. And thank you guys. I hope this was helpful. I really hope you guys enjoyed this. And as always, we are here for you. Who your liaison is, how to get to our main office. Even though we are not actually physically in our office right now, all of us are still working You know, I'm checking my voicemails. I have my emails all the time. So any of my agencies, you know, let me know if you need anything from me. I'm sure I speak for all of my coworkers when I say, you know, we are really happy to help you with these issues, and we look forward to talking with you. And I hope you guys enjoy this virtual month of training. Please make sure to let us know your feedback on these classes and how you like the format and everything. And with that, thanks for all the positive comments, and have a great day.